Welcome to the deep dive. Today we're tackling a fascinating, maybe slightly tricky area of equity and trusts law, secret trusts.
Absolutely. And just to be clear, right at the start, our discussion today is based entirely on the learning materials provided by the University of London.
Yes, a big thank you to them for making these resources available to students. This deep dive is purely for educational purposes. We want to help you really get to grips with this topic and feel prepared for exams.
Exactly. We're drawing solely from those University of London materials.
So, our mission today is to understand what secret trusts are, why they even exist, the justifications the courts use, the key issues, and really how you should approach studying them effectively.
Right. The fundamental puzzle is how these arrangements get enforced when they seem to, well, sidestep the very strict rules laid down for making a valid will.
Okay, let's jump in. To really understand why secret trusts are such a talking point, we probably need a quick reminder about what makes a will legally valid in the first place. The materials mention topic 6 for all the details, but what are the absolute basics we need to keep in mind?
Yeah, good starting point. It all hinges on the Wills Act, 1837, especially Section 9. This is crucial. It says a will must be in writing, signed by the testator, the person making the will, and crucially, that signature needs to be made or acknowledged in the presence of two witnesses, both present at the same time.
Okay, writing, signature, two witnesses, pretty clear rules. Why so strict?
Well, the idea is to prevent fraud, undue influence, and just generally make sure we know what the testator really intended with their property after they've gone. Certainty is key.
And there are other bits of the act that are relevant too, aren't there?
Definitely. Section 15 is important. It says that if a witness or their husband or wife gets a gift in the will, that specific gift is void. So you can't witness a will you benefit from.
Right, that makes sense. Stops witnesses influencing things for their own gain.
Exactly. And Section 25 deals with alterations. Any changes also need to follow strict rules. Section 20 covers codicils, which are like additions or amendments to wills. They have to follow the same Section 9 formalities. And Section 15 also mentions beneficial devises, so gifts of land, all part of that same formal framework.
Okay, so that's the standard picture. Very formal, very specific requirements. Now, enter secret trusts. Where do they fit? Or maybe, how do they not fit?
That's the crux of it. They operate outside these formalities, largely. And that immediately raises the question, how can courts uphold arrangements that don't meet the requirements Parliament specifically set out? It creates a tension, a real conflict with the Wills Act.
And it brings up worries about relying on evidence that isn't, formally witnessed and written down in the will itself.
Precisely. The whole point of the Wills Act formalities is to avoid relying on potentially unreliable memories or conversations. Secret trusts force courts to consider exactly that kind of evidence.
Okay, so let's break them down. There are two main types, right? Fully secret and half secret. What's the difference? This is key for exams, I imagine.
Absolutely critical difference. A fully secret trust is where the will itself gives absolutely no clue that a trust even exists. It looks like an outright gift to someone, let's call them the legatee.
So, on the face of the will, it just says, I leave £10,000 to Bob, full stop.
Exactly. But behind the scenes, the testator has separately told Bob, look, Bob, I want you to hold that £10,000 on trust for Charlie, and Bob has agreed. That agreement, that trust, is completely hidden from the will.
Okay, completely secret and half secret.
With a half-secret trust, the will does mention that there's a trust. It signals it. So the will might say something like, I leave £10,000 to Bob on trust for the purposes I have already communicated to him.
Ah, so the will flags that Bob isn't getting the money for himself, he's a trustee, but it doesn't say who the beneficiary is or what the terms are.
Precisely. The existence of the trust is revealed, but the details, the objects, the terms remain secret outside the will document itself.
Okay, that distinction seems clear. Fully secret looks like an absolute gift in the will. Half secret will mentions a trust, but not its terms. Got it. Now, what problems arise because these trusts don't follow the standard Wills Act rules?
Well, the main one we've touched on is that conflict with the statute. It opens the door to arguments based on potentially less reliable evidence conversations, maybe informal notes about the testator's intentions.
And what happens if the secret trust can't be proven or it fails for some reason? Does it differ between the two types?
Yes, it does. And this is important. With a fully secret trust, remember, the will looks like an absolute gift to the legatee. So if the secret trust part fails, maybe the agreement can't be proven. The legatee just keeps the property. They received it under the will as an apparent gift.
They luck out, basically.
You could say that. But with a half-secret trust, The will already states that the person receives the property as a trustee. They can't possibly claim it beneficially for themselves. So if the secret trust fails, maybe the beneficiaries aren't clear or the communication wasn't valid, the property is held on a resulting trust,
Meaning it goes back to you.
back to the testator's estate, to be distributed according to any residuary clause in the will or under the rules of intestacy if there isn't one. The intended trustee definitely doesn't get to keep it.
That makes sense. The will itself prevents them taking it personally. So why would a testator choose this route? Why create a secret trust instead of just putting everything clearly in the will?
The materials suggest a couple of main motivations. First, privacy. Wills become public documents once probate is granted. Someone might want to provide for, say, an illegitimate child or a mistress without that becoming public knowledge. A secret trust allows for that discretion.
Okay, avoiding publicity. What else?
Second, flexibility, or perhaps indecision. A testator might want to leave property via their will, but perhaps hasn't finalized who the ultimate beneficiary should be, or wants to keep their options open to change their mind easily without formally executing a codicil or a new will.
Though the materials seem a bit skeptical about how good a reason that is, given the importance of the Wills Act rules.
Yes, they question whether that desire for flexibility should really outweigh the statutory safeguards. It's a fair point.
So, despite these issues, the courts do enforce these trusts. They find ways around the Wills Act problem. What are the main justifications they rely on? This seems like core exam territory.
Absolutely core. There are two main theories you need to know inside out: the fraud theory and the outside, or de Hoor's, the will theory.
Let's take the fraud theory first. What's the basic idea?
It's the older idea. It basically says equity will not allow a statute to be used as an instrument of fraud. The Wills Act is there to prevent fraud. So if a legatee convinces a testator to leave them property by promising to hold it on a secret trust, and then after the testator's death, they try to rely on the Wills Act formalities, or lack thereof, to deny the trust and keep the property for themselves.
That would be fraud,
Yeah.
using the act to cheat the intended beneficiary and ignore the testator's wishes.
Precisely. The court steps in to prevent that fraud by admitting evidence of the secret agreement and enforcing the trust. You can see parallels with cases like Finn v. Thin or Roshakuko v. Boosted, where equity prevents someone relying on statutory formalities to act unconscionably.
Okay, seems straightforward enough for fully secret trusts where the trustee might be tempted to keep the property. But the materials mention criticisms, like circularity.
Yes, the circularity argument is that you only know the legatee would be committing fraud if you first admit the evidence of the secret agreement, the very evidence the Wills Act seems to exclude. So you're assuming the trust exists, based on non-compliant evidence, in order to justify admitting that evidence to prevent fraud. It's a bit chicken and egg.
Ah, I see. And does the fraud theory work well for half-secret trusts?
That's its main weakness. In a half-secret trust, the will already says the person is a trustee. They cannot take the property beneficially. If the trust fails, it results back to the estate. So where's the fraud by the trustee in the sense of them personally gaining? They can't.
So how did the courts adapt the fraud idea to cover half-secret trusts then?
The key case is the House of Lords decision in Blackwell v. Blackwell. This involved a half-secret trust money left to trustees for the purposes indicated by me to them. The details were in a letter given before the will. The court upheld it.
And they redefined fraud.
Effectively, yes.
Yeah.
Lords Buckmaster and Hailsham argued the fraud wasn't just about the trustee enriching themselves, but about the broader fraud of defeating the testator's clear intention and disappointing the legitimate expectations of the secret beneficiaries. It's a wider definition of fraud on the testator's wishes and on the beneficiaries.
Okay, a broader sense of fraud. The materials also briefly mention proprietary estoppel.
Yeah, it's mentioned as a potential avenue, thinking about cases like Thorner v. Major. If a secret beneficiary relied on the promise to their detriment, maybe estoppel could help. But it's generally seen as rarely applicable. The reliance is usually by the testator on the trustee's promise, not necessarily detrimental reliance by the beneficiary in the way estoppel usually requires.
Okay, so that's the fraud theory. Original justification, works okay for fully secret, struggles with half secret, unless you broaden the definition of fraud, as in Blackwell. What about the other main theory? The outside, or de Hoor's the will theory.
This one is often seen as the more modern, perhaps more intellectually satisfying justification, though it has its own issues.
Yeah.
It's associated with cases like Cullen v. AG for Ireland and Viscount Sumner and Lord Warrington in Blackwell.
And the argument is?
The argument is that the secret trust operates entirely outside the will. dehors means outside. The Wills Act, Section 9, only governs the creation of a valid will.
Yeah.
Once the will has done its job transferring the legal title to the property to the named legate trustee, any trust obligation they undertake arises not from the will itself, but from a separate personal obligation they accepted before the testator died, or sometimes before the will was made, as we'll see.
So the will is just the mechanism to get the property to the right person, but the actual trust part comes from a separate agreement.
Exactly. Lord Warrington and Blackwell put it nicely. What is enforced is not a trust imposed by the will, but one arising from the acceptance by the legatee of a trust, communicated to him by the settler. Viscount Sumner talked about the communication and the legatee's acceptance, or silent acquiescence, creating the obligation. It's about that personal undertaking by the trustee, separate from the testamentary document.
That sounds like a clever way to bypass the Wills Act formalities. But does it hold up? What are the problems with this theory?
Well, critics point out a few things. First, it doesn't really get rid of the problem of relying on potentially unreliable evidence. You're still admitting oral testimony or informal documents about this outside agreement. Second, it arguably creates a very artificial split between the trust and the will, when often the trust is fundamentally linked to the testator's overall testamentary plan.
Feels a bit like legal gymnastics sometimes.
It can feel that way. Third, why is the trustee's acceptance so crucial here? Normal trust law doesn't always require the trustee to accept for a trust to be valid, though it's arguably key in the Rochefoucauld context too. And finally, is it based on too narrow a view of what a will is? Section 1 of the Wills Act itself says will includes any testamentary disposition. Isn't the arrangement for property after death, including the trust part, fundamentally a testamentary disposition?
So neither theory is watertight, but we need to understand both. The fraud theory focuses on preventing the trustee's bad conduct. The dehors the will theory focuses on the trust existing separately from the will.
That's a good summary. And the dehors theory is often the one relied on now, particularly for half-secret trusts and some of the specific issues we'll get to. Oh, and just quickly, the idea of incorporation by reference doesn't really help here either, as that only applies to existing documents, not oral agreements.
Okay, foundational theories covered. Now let's dig into the specific rules and issues. A big one is the timing. When does the communication of the trust to the trustee have to happen? Does it matter if it's fully or half secret?
It matters hugely. This is one of the most critical distinctions and a favorite for exam questions. For fully secret trusts, the rule, coming from Boys, is that the communication of the trust, who the beneficiary is, the terms, and the trustee's acceptance can happen any time before the testator's death.
Any time before death. So the testator could make the will, leaving property to Bob, and then tell Bob about the trust for Charlie years later, as long as it's before the testator dies.
Correct. The reasoning often links back to the fraud theory. Bob can't be accused of fraud for keeping something if he didn't know about the trust obligation until after he'd received the property under the will, which is impossible if communication happens before death.
Okay, that's fully secret trusts. What about half-secret trusts, where the will mentions a trust?
Here, the rule is much stricter, based on the Court of Appeal decision in Rakeen. For half-secret trusts, the communication of the trust's terms must take place before or at the time of the execution of the will. Communication after the will is signed is too late.
Before or at the time the will is signed. Why the difference?
The reasoning in Rakeen was essentially about upholding the Wills Act. Allowing communication after the will is executed would effectively let the testator change or define their testamentary dispositions informally after the formal signing process, which the Act prohibits. They'd be reserving the power to make future unwitnessed dispositions.
But wait, if we're using the dehors the will theory, why should the timing relative to the will signing matter? If the trust is truly outside the will, shouldn't the timing of communication be independent of when the will was executed? For both types.
That is the major criticism of the Rakeen rule. It seems inconsistent. If the trust operates dehors the will, then why link its validity so strictly to the moment the will is signed for half-secret trusts, but allow communication anytime before death for fully secret trusts? It suggests half-secret trusts are somehow more tied to the will, which undermines the neatness of the dehors theory.
Yeah, that does seem contradictory.
It's a point often debated, and the materials note other jurisdictions don't always make this sharp distinction. Also remember Rostron v. Freud, sometimes just figuring out if it's fully or half secret depends on carefully interpreting the will's wording. And Tidcombe v. Eisen reminds us you still need proper intention to create a trust, not just a moral wish. The Casper Bauer v. Griffiths test still applies.
Okay, another point from Rakeen. What if the will itself says something that contradicts the supposed secret trust?
Rick Keene also dealt with this, so maybe as an aside, obiter. The will referred to trusts that would be indicated in the future, but the trustee had actually been given sealed instructions before the will was made. The court said this inconsistency was also fatal. The principle is, if the terms stated in the will, like trusts I will communicate, contradict the evidence about the secret trust, like trust I have already communicated, the will wins. You can't admit evidence that directly contradicts the will's own wording.
Makes sense. What if there's more than one secret trustee? How does communication work then?
Good question. The rules come from Risted, primarily for fully secret trusts. It depends on whether the trustees are tenants in common or joint tenants.
Okay, refresh my memory. Tenants in common means.
They each have a distinct, defined share of the property. If they're tenants in common, only those trustees who were actually told about the trust before the testator's death are bound by it. The ones who weren't informed can keep their share beneficially.
And joint tenants.
Joint tenants own the property together, as a whole, with a right of survivorship. Here, the timing of communication relative to the will becomes crucial again, strangely echoing Rakin. If communication to any one joint tenant happened before the will was executed, then all the joint tenants are bound by the trust, even those who didn't know.
Wow. Okay, so telling one before the will binds all joint tenants.
Yes. But if communication happened after the will was executed, but still before death, remember the Boy's rule for fully secret trusts, then only those joint tenants who were actually informed are bound. The others take their share free from the trust.
That's quite specific. And for half-secret trusts?
There's no direct case law cited, but trustees of a half-secret trust usually take as joint tenants. And since Rakin demands communication before or at execution for half-secret trusts anyway, it's likely the rule for joint tenants communicated before execution would apply, meaning all joint tenants would be bound if communication happened pre-execution.
Right, things get complicated quickly. What about if people die? Say the secret beneficiary dies before the testator.
Normally, under the doctrine of lapse, if a beneficiary in a will dies before the testator, the gift fails and falls into the residue. You'd expect that to apply here. But Recker Gardner, number 2, this case involved a fully secret trust. The secret beneficiary died after the testator made the will, but before the testator died. Romer J. held the gift did not lapse. He reasoned the trust arose inter vivos, during life, as soon as it was communicated and accepted, so the beneficiary had an interest which passed to their estate upon their death.
So the trust is treated as created during the testator's lifetime, not purely on death.
That was the reasoning. It's
Yeah.
heavily criticized because the trust isn't fully constituted. The property hasn't actually moved until the testator dies and the will takes effect. So how can it be an inter vivos trust? But Reg Gardner, number 2, is still cited as authority that for secret trusts, the gift might not lapse and could go to the beneficiary's estate. Definitely one to flag for exams.
A tricky exception. Okay, what if the secret trustee dies before the testator?
Well, if a trust is clearly set out in a will, equity won't let it fail just because the named trustee dies first. The court can appoint someone else. For secret trusts, it's left clear-cut, and textbooks often differentiate.
Oh, so?
For a fully secret trust, where the obligation relies heavily on a personal acceptance by that specific trustee, linking back to the fraud theory, perhaps preventing that person benefiting, the argument is the trust might fail if that trustee dies before the testator. There's no one whose conscience needs binding, and the property might just pass under the will as intended on its face.
But for a half-secret trust?
For a half-secret trust, the will already declares a trust exists. So the argument is stronger that the court will intervene to save the trust, likely by appointing a new trustee, invoking the maxim, equity will not allow a trust to fail for want of a trustee. The testator's intention to create some trust is already apparent on the face of the will.
Okay, that makes sense. Now, witnesses again. We know a beneficiary can't normally witness the will they benefit from, Section 15. What if a secret beneficiary witnesses the will?
This came up in Re Young. It involved a half-secret trust, and one of the secret beneficiaries had witnessed the will. Dankward's J. held the trust was still valid and the beneficiary could still benefit.
How did he justify that, given Section 15?
He relied squarely on the Dehors the will theory. The argument was, the beneficiary gets their interest from the secret trust which exists outside the will. Section 15 only applies to gifts made by the will. Since the benefit comes from outside, Section 15 doesn't bite.
Another win for the Dehors theory. But what if the secret trustee witnesses the will?
This is tricky. For a fully secret trust, if the trustee witnesses, Section 15 might void the gift to them because on the face of the will, they look like an absolute beneficiary. If the property doesn't legally pass to them, the whole secret trust mechanism might collapse before it starts.
So potentially fatal for a fully secret trust if the trustee witnesses.
Potentially, yes. For a half-secret trust, the argument is that Section 15 shouldn't apply to the trustee witnessing, because the will already declares they are a trustee, not receiving a beneficial gift. The gift isn't for their benefit.
Okay, that seems logical.
But think about Ryung. If the Dayers theory saves a witnessing beneficiary in a half-secret trust, saying their interest is outside the will, shouldn't it also mean that a witnessing trustee in a half-secret trust is unaffected by Section 15, as their role is defined outside the will? Or if Section 15 doesn't apply to the trustee because they aren't taking beneficially under the will, why did we need the Dayers theory for the beneficiary? There's an inconsistency there highlighted in the materials. The application of the Dayers theory seems selective.
Definitely complex. Okay, the final big conceptual question the materials raise is, what type of trust is enforced here? Is it an express trust, reflecting the testator's intention, or is it a constructive trust imposed by the court to prevent unconscionability?
Yes, this is a significant theoretical debate with practical implications. Even Rochefoucauld, often seen as constructive, has arguments for being fundamentally express. The classification of secret trusts is similarly debated.
What's the argument for them being express trusts?
The main argument is that the court is ultimately trying to give effect to the testator's expressed, though secret, intention to create a trust. Both the fraud theory, preventing the statute from blocking that intention, and the Dayers theory, finding the intention expressed outside the will, can be seen as routes to enforcing the testator's actual declared trust intention. The language used in cases often talks about admitting evidence of the trust the testator declared.
And the argument for them being constructive trusts.
This view often starts by saying, any express trust hasn't complied with Section 9 of the Wills Act, so it's technically void as an express trust. Instead, the court imposes a constructive trust to prevent the secret trustee acting unconscionably by going back on their promise, on which the testator relied. This view might better explain why communication and acceptance are so important. They are the triggers for the potential unconscionability that justifies the court imposing a trust.
Okay, express versus constructive. Does it actually matter in practice?
It can matter significantly, especially concerning trusts of land. Remember Section 53, 1b of the Law of Property Act 1925? It requires express trusts of land to be evidenced in writing.
Right. So if a secret trust of land is considered express and there's no writing,
It could potentially fail for non-compliance with Section 53, 1b, even if it somehow got past the Wills Act Section 9 problem.
yeah.
That seems odd, doesn't it? Overcoming the stricter Wills Act rules only to be defeated by the LPA's writing requirement.
Yeah, that feels backwards.
Exactly. Lord Justice Norse made a similar point about donatio mortis causa, deathbed gifts, of land in Sin v. Headley, questioning why the LPA should be a bigger hurdle than the Wills Act. However, if secret trusts are classified as constructive, then Section 532 of the LPA provides a handy exemption. Constructive trusts do not need to be evidenced in writing.
So classifying them as constructive neatly avoids the land problem.
It does. Though, even if they are express, there's a strong argument that whatever reasoning allows the court to bypass Section 9 of the Wills Act, be it fraud or Dayers, should logically also be sufficient to bypass Section 53, 1b of the LPA. Equity shouldn't allow the LPA to be used as an instrument of fraud either.
This has been incredibly detailed. Thanks for walking us through that maze. Thinking about exams now, what are the absolute must-know takeaways from the University of London materials? How should students focus their revision?
Okay, key exam focus points based on the material.
Memorize the definitions. Fully secret versus half secret. Know the difference cold.
Understand the two justifications, fraud theory and Dayers the will theory. Know their logic, how they apply, and crucially, their weaknesses and criticisms. Be ready to compare them.
Know the key cases. Blackwell v. Blackwell, re Boys, re Keene, re Young, re Stead, re Gardner, number 2, Ottaway v. Norman. Know what each decided and why it's important. Repeat those names. Blackwell, Boys, Keene, Young, Stead, Gardner.
Master the specific issues. Timing of communication, the re Keene versus re Boys difference is vital. Contradiction with the will. Multiple trustees. Re-Stead rules for joint versus tenants in common, predeceased the re-Gardner, number 2, exception for beneficiaries, and the trustee situation, witnessing issues re-Young and the trustee witnessing problem.
Practice application. Use problem questions. How do these rules interact? Apply the theories. See how changing one fact changes the outcome.
Acknowledge uncertainty. Be aware of debates like express versus constructive, and the inconsistencies like in applying the Dwar's theory shows deeper understanding.
Understand the policy. Why does the Wills Act exist? Why are secret trusts problematic? What values are the courts balancing?
That's a brilliant checklist. So summing up, secret trusts are this really complex corner of equity where courts are constantly balancing the testator's apparent intentions and preventing fraud against upholding the really important statutory rules for wills.
Precisely. It's about that tension. And keep revisiting those core cases and the academic commentary mentioned in your materials.
The materials also pose that fundamental question. Why do courts go to such lengths for secret trusts? Why treat them as so important when they breach formal requirements? Something for you to definitely think about.
It really is. And that leads to a final thought to leave you with. Given all the debate, the criticisms, the inconsistencies we've discussed, particularly around Rakeen, and the application of the de Horst theory, is this an area ripe for change? Will the doctrine keep evolving through case law, or might we eventually see Parliament step in with legislation to clarify the rules for secret trusts once and for all?
A very interesting question to ponder. Remember, this deep dive was purely for educational purposes, drawing entirely on the University of London's learning materials designed to help your understanding for study and exams. Thanks for joining us.